Did you know that employers can be held liable for biased behaviors in the workplace due to discrimination of any kind? My name is Ricardo Hernandez, and this is made possible through a concept that has been around for decades. This presentation, titled Discrimination in the Workplace, based on Chapter 38, Labor and Fair Employment Practices, focuses on Title 7 of the Civil Rights Act of 1964, which is one of many federal employment statutes. When I hear of a statute, two questions that come into mind are, what does this statute do and who does it apply to? This statute, as defined in the textbook, prohibits discrimination in the terms, conditions, and privileges of employment on the basis of color, race, sex, religion, or national origin. This statute applies to employers with 15 employees or more, as well as unions with 15 members or more. Under the Title 7 of the Civil Rights Act of 1964, there are many practices that are not tolerated when involved in the employment process or workplace. Disparate treatment, national origin discrimination, and religious discrimination are a few examples. Disparate treatment refers to when employers consider only certain categories of people for certain jobs. For example, only women for clerical positions, only men for labor or hands-on jobs, or only white men for manager positions. National origin discrimination refers to an employer not hiring someone based off of where they come from, which also considers the color of their skin. Lastly, religious discrimination involves bias against people for their beliefs, such as a woman who wears a niqab as part of her religious belief. One case that involved discrimination was the case of Fisher v. University of Texas, Austin, in which Fisher accused the university of being unfair for utilizing race for consideration in the admissions process for the university, which he stated violated the Equal Protection Clause of the 14th Amendment. However, in the end, the court deemed this process from the university to be constitutional. And another case involved a company we all know today. Cloutier v. Costco was a case that occurred due to an employee of Costco that felt her rights to wear facial piercings was being violated by the company's new dress codes, and since she didn't want to comply with the new policies, she was terminated and sued. She was terminated and sued Costco for failing to make accommodations for her, as she stated that her piercings were part of her religion. And eventually, the court ruled that Costco was in their right to want to maintain a professional appearance among their employees. This statute has personal meaning for me because I've had family members have a hard time finding a job due to the fact they're not from around here, such as my mom, who has had difficulty finding a good job due to having brown skin. This situation wasn't handled until she let a potential employer know that the color of her skin did not impede her from performing the tasks of the available position, which led to the employer giving her the opportunity. What this personal experience taught everyone in my family, me included, is not to be afraid to stand up for yourself. If you are experiencing any form of discrimination, whether it be religious, racial, or based on your sex or color of your skin. With that being said, that brings us to the end of this presentation on a statute that stood out to me the most throughout the entirety of this semester. Thank you.